Hi, Sam. How are you?
Hi Mariana, I'm good. How are you?
I'm good. Happy Friday. Here is to another episode of Tea with Noli IP.
Yeah.
So I know that today we're going to be talking about patents, and I'm excited to share with everybody a presentation that you have prepared for us. Tea with Noli IP about patents. And I want to take this opportunity to thank Sam for all the wonderful job that she's doing handling the digital marketing for our firm. As you can see in this slide, Karim Lagovi is our patent expert. And yeah, I'm excited to have this conversation with you, Sam.
Yeah, and today I will be interviewing Mariana Noli, who's the founder of Noli IP, on some questions that we get regularly about patents. So the first question is, should I file for a patent?
Well, definitely a yes. And I tell you why. If you have an invention and you're getting ready to go to a trade show or go to a meeting, you want to make sure that you don't disclose your invention before you get some protection. You want to take advantage of the possibility of having an initial consultation free of charge with our patent expert. So in answer to your question, yes, you do want to file a patent if you file an invention that complies with all of these requirements of patentability.
Okay, my next question is, what kind of protection do I need?
Depending on what do you want to protect is the patent protection that you would seek. So for example, if you want to protect the utility of your invention, then you will seek for a utility patent, provisional or non-provisional. That would depend. A provisional is a placeholder. It kind of saves your place in line, but it doesn't give you protection. And I can explain whoever is interested in learning more about patents, what that means. The signed patents protect the way that an object or the invention, the ornamental features.
Okay, that makes sense. So where should I file?
Well, you should file a patent application with the United States Patent and Trademark Office first if you want to protect your invention in the United States, and of course in all the jurisdictions that are relevant to your business, because you know patent rights are territorial. Each state, each country has the right to grant those patent rights.
Right? Which type of application should I file?
And when we were talking about what type of protection to seek, and I talked about utility patents and I talked about design patents, depending on whether you wanted to protect the functionality of an object or if you wanted to protect the design or the ornamental features, the type of patent that could be a provisional in the United States or a non-provisional, which is the one that ultimately would give you patent rights. A provisional, it's merely a placeholder. It saves your place in line, but it doesn't give you patent protection. A PCT, because United States is one of the countries that is signatory of the Patent Cooperation Treaty, an international treaty that allows you to file one single application and reserves your patent rights in many other jurisdictions of those countries that are also signatories of this treaty. And we also can file a design patent if you want to protect the ornamental features of the invention.
Right? Should I file for a patent on my own?
Well, you can file a patent on your own. And in fact, the United States Patent and Trademark Office has a special area or section where you can reach out for help and assistance. The Inventors Assistance Center. But reality is that you can benefit significantly from working with one of our patent experts. In fact, Mr. Lagovi, Karim, how you and I know him, he can give you tips that only somebody that has been in the business for over 20 years can give you, and to get the broadest protection possible. The way that the way that your claims are drafted is very important for the purposes of protection. So while you can do it on your own, I highly recommend that you work with a professional.
Yeah. Which mode of filing should I choose?
You know what? The United States Patent and Trademark Office mainly works electronically. So all the filings are online. In fact, for some of the filings, there is extra charges if you do it paper-based.
Okay. So what are the documents and information I need when filing?
So when you file a patent, there are, depending on the different type of patents and what you decide to file, are the paperwork that you will have to submit. But let's just talk, for example, about a basic patent application, utility application. You will need the claims, you will need the description of the invention, you will need an abstract, you will need a background of the invention, you will need the drawings. Of course, there is always a declaration by the inventors that is required. You have to identify if the applicant is a small entity, a micro entity, or if it's a non-small entity. You have a fee transmittal form where you calculate the fees that are required depending on the, so depending on your particular case are the documents that we will have to file with the USPTO.
Okay. What is the information that I need to disclose?
Well, and it is important that you disclose how the invention functions and why it is novel and why it complies with all the patentability requirements, because that is what the examiner is going to examine when they look at your invention. And that is what it's going to, you know, be taken into consideration for the examiner to give you exclusive rights to the commercial exploitation of that invention. So you're going to have to disclose how your invention functions and everything that you know, and then the examiner will make a determination if it is patentable or not. You are also required in the United States to disclose all the relevant prior art. So if you know or any other patents or relevant art that relates to your invention, you are required by law to disclose it to the patent office.
All right, that makes sense. So what are the options available to me at the USPTO to expedite the process?
And you know, the USPTO and many other jurisdictions and patent offices around the world have the possibility for applicant to request an expedited examination of their invention by filing via the patent prosecution highway. So let's say that there is an examination in another jurisdiction for the same invention, then you can point that out to the examiner. So that is taken into account to expedite the examination of your invention.
Okay, how can I reduce the cost?
And I mentioned briefly, but if the applicant qualifies as a small entity, the fees are reduced by half, the official fees. And if the applicant is a micro entity, actually it's half of the half price. So you do want to check with your patent expert and indicate what type of applicant you are. And if you comply with the different requirements for a small entity, you definitely want to take advantage of that because the difference in the official fees is significant.
All right. So thank you for answering all the questions about patents today.
Bye, Sam. Until next week.
Bye.